Warm greetings everyone. I am Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. The topic of our today's talk is protective discrimination and equality. Dear friends, we will discuss this module into two parts. In the first part of this module, we will discuss the meaning of protective discrimination, and in the second part of this module, we will discuss the concept of equality and constitutional mandate of protective discrimination. So friends, let us begin with learning outcomes of this module. The present module will make you acquainted with the concept of protective discrimination and equality, why India needs protective discrimination, what is the background of protective discrimination, constitutional perspective of right to equality, constitutional perspective of protective discrimination. Dear friends, we must begin by acknowledging Dr. B.R. Ambedkar that there is a complete absence of two things in Indian society. One of these is equality. On the social plane, we have an India based on the principle of graded inequality, which means elevation for some and degradation for others. On the economic plane, we have a society in which there are some who have immense wealth as against many who live in abject poverty. As we all know that discrimination is predominant in every civil society. No society is immune to discrimination. From time immemorial, Indian society has been compartmentalized, caste-ridden and stratified with hierarchy, historically and even today systematically. A particular segment of society is being denied basic human rights by those claiming to be superior and privileged. The extreme form of discrimination include genocide, ethnic cleansing, the worst form of slavery, and legislated discrimination such as apartheid. Discrimination based on caste, sex, race and religion, nevertheless pervasive and oppressive, includes prejudice and social exclusion at the institutional level such as in schools, workplaces and the like everywhere without exception. The role of socio-economic system and political institution is significant. Inequitable practice by these institutions had created an imbalance in society, and certain classes of people, particularly scheduled tribes, scheduled caste and women, became the victim of social and economic disabilities. Therefore, it is quite evident that these groups could not effectively enjoy their equality of status and opportunity. Not surprisingly, that the basic postulate of the right to equality is pervading in the provisions of Constitution of India. In this introductory statement, we the people, the preamble prioritizes the authority that lies on the people of India. Intending to create an egalitarian society, the framers of Constitution waited upon justice, liberty and equality of status and opportunity to all. Yet a country so diverse in language, geography, culture and heritage, it was preposterous to apply equal laws to all in similar circumstances. Ergo the expression equal protection of laws lay down with the underlying rule that like should be treated alike and not the unlike should be treated alike. It is known to be a pledge of the protection of equal laws. Over a great period, a certain section of society had always been suffering from oppression and exploitation of all kinds. The malady of social disparities crippled the underprivileged and downtrodden classes so intensely that they became economically disabled for generations after generations. The founding father of the Constitution dreamt of an egalitarian society that would be free from prejudice and discrimination. To achieve this goal, bringing social and economic justice was at most importance. Henceforth, the essence of equality was embedded in the provisions of the Constitution. The Constitution of India assures equality to all its citizens. However, absolute equality is impracticable because Indian society is diverse in culture, language, religion, geography, and so forth. Applying similar laws to all in all circumstances would only instigate inequality. Thus, the makers of Constitution applied their judicial mind to an affirmative action that would potentially accomplish the desired object. It was the idea of protective discrimination that added a new dimension to a great socio-economic maneuver. Sovereign India determinedly and unequivocally embarked on the compensatory discrimination principle with a strong justification that it works as an effective mechanism to offset the historic cumulative deprivation experienced by lower castes. The truth is that the Indian social system has for centuries committed social and economic injustices by the so-called higher caste on the lower caste that have been denied equality in the opportunity and facilities of the society. As long as poverty, injustice and gross inequality persist in the world, none of us can truly rest, said Nelson Mandela. Only in societies where everyone is treated fairly and without bias can democracy grow and prosper. Therefore, the writers of the Constitution believed that including such a provision would make it easier for the nation's varied groups to enjoy the rights and liberties protected by the document by removing the obstacles of current social and economic inequality. The founders of the Indian Constitution recognized that the total equality was unattainable from the standpoint of Indian society. And to attain social justice in India, they instituted the policy of protective discrimination. Its goal is to give special rights to the disadvantaged and socially backward segments of the society, which are usually women, scheduled caste, scheduled tribes and another backward classes. These actions are justifiably enshrined in the Constitution of India as protective discrimination. There are groups of people who have endured centuries of discrimination based on race or caste by the privileged classes due to disparities in sex, religion, place of birth, race and most notably the institution known as caste system. The founding fathers of the Constitution attempted to remedy the problem using affirmative action. Protective discrimination as an idea has been practiced by many civilized nations including developed nations like USA because of their dark history of racial discrimination. In India, the Constitution of India through its various provisions guarantees the right of the downtrodden and underprivileged by way of reservations or quotas in educational institutions, jobs and parliamentary privileges, as well as commands the legislature to legislate special provisions for their overall advancement. Dear friends, let us discuss the meaning of right to equality. The right to equality means that every person who lives within the territory of India has equal rights before the law. The meaning of this all are equal in the same line. No discrimination based on religion, race, caste, sex and place of birth. It means that all will be treated equally and there will be no discrimination based on the lower or higher class. Dear learners, moving further, now I would like to elaborate the meaning of protective discrimination. Protective discrimination is the policy of granting special privileges to the downtrodden and the underprivileged sections of the society, most commonly women. These are affirmative action programs most visible in both the United States and India, where there has been a history of racial and caste discrimination. The practice is most prominent in India, where it has been enshrined in the constitution and institutionalized. The goal of India's protective discrimination policy is to establish social fairness. Its goal is to give specific rights to the socially marginalized and disadvantaged segments of society, which are usually women, scheduled caste, scheduled tribes and other lower groups. These are the groups of people who have endured centuries of discrimination based on race or caste by the privileged classes due to disparities in sex, religion, place of birth, race and most notably the institution known as caste system. The founding father of the constitution attempted to remedy the problem using affirmative action. These acts legitimately protected as protective discrimination under the Indian constitution. Because of their sordid past of racial discrimination, many industrialized countries like USA have adopted the concept of protective discrimination. Through several provisions, the Indian constitution protects the right of the marginalized and downtrodden through quotas or reservation in employment, educational opportunities and parliamentary privileges. It also directs legislatures to enact special laws for the advancement of these groups of people. Dear friends, the next important question is why India needs protective discrimination and what is its background. The fact that Indian society discriminates against some communities, most notably based on the caste system, aggravates the issue. A long-standing social issue that stretches back centuries is the caste system. The sad reality is that the caste system still prevails despite the constitutional ban on discrimination against these groups regardless of the law's position. Without a voice or a grievance procedure, members of lower caste are forced to serve their upper caste counterparts. This cruel and barbaric state persisted for centuries until we the people became aware of the problem and forced the legal system to enact laws, propose changes and improve the lives of these people to elevate them to the same status as all other people. Protective discrimination is the policy of granting special privileges to the downtrodden and the underprivileged sections of the society, most commonly women. These are affirmative action programs most visible in both United States and India, where there has been a history of racial and caste discrimination. The practice is most prominent in India, where it has been enshrined in the constitution and institutionalized. The need of discriminate positively in favor of the socially underprivileged was felt for the first time during the nationalist movement. It was Mahatma Gandhi himself, a devout Hindu and staunch believer in the caste system, who was first leader to realize the importance of the subject and to invoke the conscience of the upper caste to this age-old social malady of relegating whole communities to the degrading position of untouchables. He also understood the political logic of inducting this large body of people into the political mainstream to make the freedom movement more broad-based by renaming these untouchable as Harijans, people of God. He tried to give this policy a religious sanction so as not to disturb the traditional sensitivities of the caste Hindus more than was necessary. Constitution of Independent India, which largely followed the pattern of the Government of India Act 1935, made provisions for positive discrimination in favor of scheduled caste and scheduled tribes, which constituted about 23% of the divided India's population. Besides reserving parliamentary seats for them, they were given advantages in terms of admission to schools and colleges, jobs in the public sector, various pecuniary benefits for their overall development, and so on. The Constitution indeed guaranteed the fundamental right of equality of all citizens before the law, but it also categorically lays down that nothing in this Constitution shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or the scheduled caste and scheduled tribes. Dear students, it is very pertinent to understand the constitutional mandate. Some of the constitutional provisions which aimed at positive discrimination are Article 17 of the Constitution of India, deals with abolition of untouchability and making its practice in any form a punishable offence. Article 46 of the Constitution of India deals with promotion of educational and economic interest. Article 16 and 335 of the Constitution of India gives preferential treatment in matters of employment in public services. Article 330 and 332 of the Constitution of India deals reservation of seats in the Lok Sabha and state assemblies. Later, job-related positive discrimination was extended to government-supported autonomous bodies. Constitutional perspective of right to equality. Article 14 of the Constitution of India does not speak of mere formal equality but embodies real and substantive equality. The essence of equality as a facet of the constitutional tenets adopted to strike out inequalities arising on account of vast social and economic disparities among the citizens is thus consequently an indispensable element of social and economic justice. However, absolute equality is impossible. The right to equality under Part 3 of the Constitution therefore is not absolute and is subject to reasonable exceptions. Equality does not essentially means that all laws should be universal and general in application, nor all laws can be applicable in all circumstances. Explaining the concept of equality, the Supreme Court of India in the case of Murray Chandra Shekhar Rao versus Dean Seth, GS Medical College observed that equality must be a living reality for the people. Those who are unequal in status and opportunity cannot be treated by identical standards. Article 14 permits reasonable classification between potential, underprivileged and privileged sections of citizens based on definite schemes but strike out class legislation. Reasonable classification explains that classification or segregation must not be artificial, invasive or arbitrary. Such classification must be based on rule of intelligible differentia, which differentiate between different classes or group persons from those left out of the group. Most importantly, there must be a rational nexus between the differentia and the object sought to be achieved. Article 15 subclause 1 of the Constitution of India restricts the state from unreasonable bias or adverse distinction from one another only on account of caste, sex, race, religion and place of birth. However, when the discrimination rests on only these grounds, Article 15 subclause 1 comes into play. there is an intrinsic correlation between Article 14 and 15. Whilst these articles guarantee equality of opportunity and equality of treatment to all, neither of these articles prohibits reasonable classification. It means that special treatment meted out to a particular class of citizen by the state on account of some special reasons and circumstances is justifiable, but should be on reasonable grounds. Further, constitutional perspective of protective discrimination. Article 15, subclause 3 enables the state to confer special rights to women and children. This provision empowers the state to make special provisions and enactments in favor of women and children for their all-around upliftment in society. This provision is specially designed to strengthen and improve the status of women. Article 15, subclause 4 enables the state to make special provisions for the improvement of socially and economically backward classes of citizens, specifically the scheduled tribes and scheduled caste. This provision was added to the Constitution by First Constitutional Amendment Act in 1951 as a result of the decision given in the State of Madras versus Chamkam Dorairjan. Article 15, subclause 5 was inserted in the Constitution of India in 2005, which enables the state to make special provisions concerning the reservation of seats in educational institutions. This clause enables the state to make special provisions for the advancement of socially and educationally backward classes through the reservation of seats or quotas whilst admissions into educational institutions, whether private, aided or unaided by the state. Clause 5 is, however, not an exception but only makes a special application of the principle of reasonable classification and protective discrimination. Clause 6 to Article 15 was inserted through 103rd Constitutional Amendment in the year of 2019. This clause directs the state to make special provisions for the upliftment of economically weaker sections of the citizens of the general class concerning admissions into educational institutions including private, aided or unaided by the state. Further, Article 16 subclause 1 guarantees to all citizens equality of opportunity in matters relating to employment in public offices. Clause 3 to 6 of Article 16 contains an exception to the rule of equality of opportunity incorporated in clauses 1 and 2. Clause 4 to Article 16 expressly permits the state to make provisions concerning employment of backward classes of the citizens. This clause imposes discretion upon the state to make provisions for reservation of jobs to backward classes, which the state believes is not adequately represented in the service of the state. In 1995, through the Constitution 77th Amendment Act, Clause 4A to Article 16 had been inserted in the Constitution. This provision enables a state to make provisions concerning reservation in matters of promotions with consequential seniority in favor of scheduled tribes and scheduled caste. Article 16, subclause 5 permits that concerning the operation of affairs of any religious institution or denomination, the incumbent shall necessarily be a person professing a particular religion or belonging to a particular denomination. This exception may be read together with Article 25 to Article 28, which is the fundamental right to freedom of religion and the right the minorities under Article 29 and 30. Article 16, subclause 6 was added to the Constitution through the Constitutional 103rd Amendment Act 2019, which enables the state to make provisions for reservation in the matter of employment or appointments in favor of economically weaker sections of the citizens, subject to the maximum of 10% in addition to the existing reservation. Moving further, Article 46. Article 46 imposes a duty upon the state for the promotion of educational and economic interest of the weaker section of the people, especially those belonging to scheduled tribe and scheduled caste, to protect them from the vicious cycle of all forms of exploitation and injustice. After discussing all aspects of equality and protective discrimination, now I would like to conclude today's discussion by saying that Constitution of India through various laws and provisions aims at eliminating disparities between different sections of society and providing equality of status and equality of opportunity to all. In India, there is a growing discussion about positive discrimination. Democracy, on the other hand, is not restricted by logic or ethics because it is fundamentally a social creation. A nation cannot flourish if a significant portion of its population falls behind in the development, race, and as a result is unable to benefit from the equality of opportunity granted to all Indian citizens as a fundamental right. The long disputed challenge of preserving the rights of both historically oppressed and socially and economically disadvantaged individuals as well as privileged section has long been debated because of its hierarchy and brutal caste system. India has a grim history of oppression and violence. Even though the country and we Indians have been independent for 74 years, and even as we Indians enter the age of liberalization and globalization, the social system and mindset of masses have remained the same. Understanding the very nature of society, there should be a different laws applying differently in different places and circumstances. Application of the same laws parallel to everyone irrespective of socio-economic differences may result in violation of spirit of the right to equality. Henceforth, protective discrimination as a constitutional tenet for protection and preservation of the rights of scheduled caste, scheduled tribes and others backward classes of citizens as well as women is highly recommended in our society. Let us hope that the authorities in charge rise to the occasion and ensure an accelerated intake of these people into government services and post by closing all loopholes. With this, we will end today's discussion. Thank you very much.